In this final lesson examining the UK Constitution, what we're going to do is talk about the various and complicated constitutional reforms that have taken place since the election of New Labour, which was in 1997. Now, we're essentially going to divide this into the different topics relating to constitutional reform. So we'll talk, for example, about areas related to human rights, to devolution, to Brexit, of course, to electoral reform, etc., etc. And we will explore how the new Labour government made a number of reforms. A number of the real major reforms takes place in the new Labour era. We see a little bit of a stagnation in terms of major constitutional reforms since then, with the notable exception of Brexit, of course. And then we will talk about some of the potential future areas of constitutional reform. The problem with this lesson is because at the time of recording this lesson, which is in July 2023, we have a Conservative government that seems to be posturing towards constitutional reform in a number of different areas, but not actually pulling the trigger on actually implementing any of it. So I'll make that clear as time goes on as well, that this could be outdated very, very shortly. So we're going to talk about, in the following order, we'll talk about constitutional reform with specificity relating to human rights, to devolution, electoral reform, parliamentary reform, judicial reform, and then we will finish by talking about arguably the most important major constitutional reform since New Labour, which is, of course, the impact of Brexit and the leaving of the European Union. So, how has human rights been developed and changed and reformed since 1997? Well, of course, we know that the most important of these was the 1998 Human Rights Act, which enshrined most of the provisions that were taken out of and drawn from the European Convention on Human Rights. Now, what essentially the Human Rights Act does is requires the British government to ensure that legislation is compatible with the Convention and is compatible with the legislation itself. All bills introduced through Westminster must receive a declaration of compatibility through the passage of said legislation, and UK courts can declare legislation incompatible with the European Convention and overturn executive decisions. And by European Convention, I'm sort of meaning more specifically within the Human Rights Act, because the European Convention itself relates and applies its legal precedent differently to the way in which the Human Rights Act operates. Again, when we talked about this in the previous lessons looking at the Human Rights Act, we noted that this is a quite niche and esoteric area that you don't need to understand in any great depth to do well at A level. Okay, so you don't have to know the distinct and clear intricacies, both theoretical and doctrinally, between the Human Rights Act and the European Convention and the ways in which law applies in different regards. You should just know that the ECHR, being a treaty, a convention, applies international law and applies to international law, and the Human Rights Act, being parliamentary statute, applies domestically. So we come now to the first of our major important issues relating to the potentiality of future change to the UK's constitution. And this relates to the leaving of the European Convention on Human Rights and or revoking, repealing and replacing the Human Rights Act from 1998. So there has been debates about the potentiality of leaving the European Convention on Human Rights, and by extension and by requirement, you would have to also therefore leave the Council of Europe. Now, the Conservative government and backbench MPs talk about the reasons why they feel the need to leave the European Convention or to reverse and reform the Human Rights Act. We've seen rhetoric around, for example, immigration reform and asylum reform related to refugees and the quote-unquote small boats controversies that we have been seeing, namely coming from the Home Secretaries of Priti Patel and more recently and to this very day, Suella Braverman, who have both come to the conclusion that in order to properly and effectively deal with the refugee crisis, quote unquote, that is alleged to have been taking place within the United Kingdom, we have to leave the European Convention on Human Rights, because what the European Convention on Human Rights and the European Court of Human Rights does is prevent any meaningful government policy. We've seen this with the way in which the stay of policy was initiated with regard to the Rwanda scheme that was initially first implemented. When it was first implemented, as the aeroplanes that were going to send these refugees to Rwanda were on the runway, the European Court of Human Rights issued a stay, essentially, which essentially paused the policy in order to examine the potential legality and potential breaches of the convention that the Rwanda policy had. So, from that regard, in that instance, if you are somebody who wants to implement things like the Rwanda policy and the small boats rhetoric and the major refugee reform that the Conservative government are attempting to implement, you would be quite critical of the ECHR, because the ECHR has actually attempted to block and has attempted to reconcile these policies with the fundamental human rights that are enshrined in the convention. So this is an area that is very much very touch and go in terms of what's going to take place, what's going to happen. Of course, we remember earlier, before Dominic Raab resigned, he had introduced a bill which was potentially going to reform and repeal the Human Rights Act. So we've seen that there could be major human rights changes taking place within the Conservative government at this point. But of course, you have to also take into consideration that next year, in 2024, we are likely going to have a general election. So the extent to which the Conservatives may even have time to implement these major human rights reforms is also up for debate. In regards to devolution, it should be noted that the majority of the major changes and reforms took place under both the new Labour governments of Gordon Brown and Tony Blair, in reverse order, Tony Blair and Gordon Brown, and then also in the earlier years of the coalition government, and then a couple of pieces of legislation in the first few years of the 2015 beginning Tory government administrations. So, essentially what devolution involves, and we will get to talking about devolution a little bit more in more detail in future lessons, but for now it should just be noted that devolution involves the transfer of powers, whether that be executive or legislative or tax-raising policy powers, from the central government being Westminster in this regard, to what are described as subnational institutions. So in 1999, power was devolved to new institutions in Scotland, Wales, Northern Ireland, and also in the city of London as well. There was what is described as devolution there. And these were all following yes votes in referenda in each nation. So there were referenda that took place, voting on whether or not to have this policy of devolution, and they all voted yes. And as a result, we end up with the Scottish Parliament, the Welsh Assembly, and the Northern Ireland Assembly. The Scottish Parliament, by far and away, has the most of the power in terms of, if we were going to rank them in terms of which one has more power by way of devolution. They have primary legislative powers. They also have tax-varying powers as well. And it and the Scottish Government have sole responsibility for policy issues such as education, health, and local government. Where Westminster retains its power is in very specific areas related to things like national security, for example, constitutional issues. So the Constitution applies to the entire United Kingdom, as well as things like leaving the European Union, for example, as we've seen the Scottish, the SNP, the Scottish National Party, being quite against the idea of Scotland also being part of the United Kingdom and leaving the European Union. So between 2007 and 2009, we get the introduction of what is known as the Calman Commission. Now, what the Calman Commission recommended was the devolution of further powers. So this should be noted that devolution takes place on a relatively long timescale. It isn't something that takes place all at once. It is something that takes place over a period of many, many years. So they had the first sort of wave of devolution legislation in the late 1990s, early 2000s, Northern Ireland being slightly different given the fact that we also had the Good Friday Agreement and the ending of the Troubles in that regard. But we had early devolution legislation in the late 90s, early 2000s. Then the Calman Commission comes along in 2007 to 2009 and recommends that further powers be devolved. And at the time, the but after the end of the Kalman Commission and going into 2010, the Conservative Liberal Democrat coalition decided to enact these changes with the National Assembly for Wales, for example, being initially quite a lot weaker. It has secondary legislation and executive powers, but it does not have any kinds of primary legislative authority. And so we end up with further pieces of legislation in terms of recent developments. So we have, for example, at the end of the Conservative Liberal Democrat coalition, the Wales Act of 2014, and we also have the 2016 Scotland Act, which takes place in the early years of the Cameron administration from 2015 to 2016. 2016, yeah. With the Scotland Act. Now, the thing I want to note here is the impact of devolution, because devolution has had a significant impact on the constitutional settlement, the traditional understanding of how the Constitution operates. We now no longer fit nicely into the classic definition of what is described as a unitary state, even though pre-devolved United Kingdom looked more like a union state. But nor does the United Kingdom necessarily fit into what would classically be described as a federal state. So states like Germany or the United States of America are federal states. So the United States, for example, has a federal government which operates at a national level and instigates policy and law at that national level. But you also have a significant amount of legal and political authority given to the states, and then even more locally to local administrations as well. So that's how it works in the United States. It is a federal state. They have a system of federalism. The United Kingdom is no longer a classic unitary state, even though it was already described as a union state, which is why to this day we argue that the United Kingdom exists as something of a quasi-federal state. So it is part federal in the sense that we have devolution, which essentially delimits powers across to different subnational governments. But it is also unitary in the sense that parliamentary sovereignty remains the key principle and foundational principle of the UK's constitution. And so we have what is described here as this quasi-federal system that exists. Devolution has also raised questions about how England ought to be governed as well. So England being specifically the country of England and the relationship that is had there. Because essentially we have to give rise to the question which is known as the West Lothian question. And the West Lothian question is this idea of why is it the case that Scottish MPs at Westminster are able to vote on purely English matters, when English MPs can no longer vote on matters which are devolved specifically to the Scottish Parliament. So only reserved matters can English MPs vote on relating to voting in Westminster. Should it not be the case that we have our own English Parliament that is specifically relating to devolving powers to England, and then you have England, Scotland, Wales, Northern Ireland a bit more separate, because at the moment Scottish MPs have the ability to have a certain amount of authority in both Westminster and within Scotland specifically. So there's some back and forth that has to be asked in regard to that. And as I've said here on this slide, that there is no simple answer to this question as to how we resolve this. Because does it make sense to suggest that we should devolve powers to a new English institution? That doesn't necessarily fit nicely with what we all conceive as the purpose and role of the Westminster Parliament. In terms of electoral reform, the Blair government's record on electoral reform was relatively mixed. So there was proportional representation introduced for elections to the Scottish Parliament, the Welsh Assembly, the Northern Ireland Assembly, as well as the European Parliament. And so we will get to this when we start looking at elections in a few months' time, when we look in the future. But essentially, with the introduction of these new devolved institutions comes new methods for electoral reform, new methods for elections being operated, with proportional representation being introduced. There was no action, however, taken in regards to the system that is used in general elections, which is, of course, the first-past-the-post system. Now, in 2011, there was a call for reform of the first-past-the-post system and a replacement of the first-past-the-post system with AV, which stands for Alternative Vote. And this was put to a referendum in 2011. However, the yes vote did not win, and we retained the first past the post system. One of the reasons potentially for the yes vote not winning is the fact that the major political parties, such as the Conservative Party and the Labour Party, actually benefit from the first past the post system, and so it doesn't make much sense for them to be arguing for a more proportional system such as AV. And since then, there have been very few developments in the way of how we are going to change electoral reform, or whether or not to keep first past the post or to remove first past the post. In relation to parliamentary reform, of course, we have a number of issues relating to the structure of the House of Lords. So the 1999 House of Lords Act abolished all but 92 hereditary peers. The Lords is now composed mainly of life peers, and we also have no political party having an overall majority. As well as this, the Labour government made little progress with stage 2 of the reforms that were suggested, which is the idea of the final composition of powers of a reformed House of Lords. So the idea of a more reformed House of Lords that goes beyond just removing the hereditary peers, but potentially even goes to an elected body. MPs and peers rejected a series of options for reforms. So, for example, there were ideas relating to including an all-appointed House of Lords, or having a hybrid house which contained both elected and appointed peers, so adding and injecting a little bit of democracy into the House of Lords. And there haven't really been many reforms to Parliament specifically since these new Labour reforms. So as I've said, a lot of these major reforms to the UK's constitution since 1997 takes place under the large majority of New Labour. And then since then, we've seen a relative amount of stagnation, with the notable exception, of course, being relating to Brexit, which we will get to. In addition to this, in 2007, MPs votes for 100% elected, or potentially a 89 or an 80% elected House of Lords, but no legislation followed in the short term. Blair's initiatives on reform of the House of Commons were less spectacular, and even less spectacular than the relatively lacklustre House of Lords reforms. Changes to the Prime Minister's questions and the working hours of the House of Commons, plus additional sitting in Westminster Hall modernised proceedings. We also had, of course, the introduction of televised proceedings in terms of you being able to sit and watch online the House of Commons and House of Lords debating on particular bills and stuff. An interesting way of introducing democracy, but the extent to which this is considered to be a constitutional reform is obviously something that is to be debated. The Brown government gave greater priority to reform of the House of Commons. The 2010 Governance of Britain Green Paper aimed to limit the powers of the executive and actually make it more accountable to Parliament. So, of course, the wrestling and the back and forth that is had between Parliament and the government. So, when we think about the House of Commons Committee, we've also seen some reforms to the House of Commons Committee in relation to, or at least recommendations for reforms since 2009. The reform of the House of Commons Committee 2009 was chaired by Tony Wright, and it recommended that chairs of select committees should be elected by backbenchers. A backbench committee should determine the business of the House of Commons for 1 day per week, granting extensive amounts of power to the backbenchers that don't currently exist for them. They have very limited time in terms of determining business within the House of Commons. A procedure petitions committee, which should select issues for debate that had been suggested by a public via the use of e-petitions, and obviously we have that introduced. We have e-petitions that exist. If the e-petition gets more than 10,000 signatures, the House of Commons or Parliament will write in response. If it gets more than 100,000 signatures or within the petition, then it is likely that a debate be chaired in the House of Commons in relation to it. The extent to which this has actually made major changes to the ways in which the House of Commons actually operates and interacts with the people is of course something that is going to be debatable. And we'll get to all of this in more detail when we start to look at democracy and participation in future. I've included this here, which is quite interesting, minor change, which was attempted by the previous leader of the opposition, Jeremy Corbyn, who, during Prime Minister's questions, at least in the early years of his tenureship as leader of the opposition, so from about 2015 onwards, made a point of asking public questions to the Prime Minister. So rather than making questions or asking questions that had been essentially established by the by the opposition specifically, they asked questions that were written to them by the general public. And an interesting fact, an interesting point of note that could be seen in terms of parliamentary reform. Nothing was major in terms of the rules that had changed. It was just a decision on the part of the previous leader to actually instigate these kinds of questions. In terms of judicial reform, the major piece of legislation that we are going to have to refocus on is, of course, the Constitutional Reform Act from 2005. This focused on judicial reform. It established a Supreme Court, which opened in 2009, and it became the highest court, which removed the judicial role of the House of Lords. So previously, the House of Lords was where the highest judicial position in the land existed, the Law Lords sitting in the Appellate Committee of the House of Lords. Since then, they have been removed, and they crossed the square into the old Guildhall at Middlesex, and they now have their own Supreme Court. The role is essentially the same in terms of what they do. The Law Lords versus Supreme Court Justices. They hear cases that are a matter of extreme constitutional importance, or matters of law that are important for examination, that have been appealed up through the court system. And this essentially enhanced this idea of a separation of powers, because now, but in relation to this, sorry, the power of judicial review that exists, for example, in the United States, doesn't exist in the same sense that it does here, in the sense that the Supreme Court does not have the authority to just strike down legislation. The government also had intended to abolish the office of the Lord Chancellor, and so this brings about the separation of powers even more, because the Lord Chancellor had the power of essentially had significant high up roles within both the executive, judiciary, and the legislative branches of government, which of course is a completely antithetical position to the broader understanding of the separation of powers. By far the most significant development which takes place since 1997, at least within recent years, is of course the withdrawing of the United Kingdom from the European Union. According to Article 50, subsection 3 of the Treaty on European Union, treaties of the European Union, so this includes the TEU, the treaties on the functioning of the European Union, as well as the Fundamental Charter, as well as any kinds of secondary legislation such as regulations and decisions and anything of that note, all from the European Union, they will no longer apply to the UK from the date of entry into force of the withdrawal agreement, or failing that, after 2 years' notification. Now, the UK formally left the European Union in 2020 after they had introduced the referendum in 2016. The Leave vote won this referendum, and then from then to 2020 we had the essential negotiating process for formally leaving the European Union. In 2020, we left the European Union and entered into what is known as a transition period. This is where a trade deal was to be negotiated between the European Union and the United Kingdom. During this period, the United Kingdom remained part of the EU's single market. So essentially, for all intents and purposes, very little in terms of its effects had changed during 2020. And it wasn't until the end of 2020 that the UK-EU trade deal was completed and then entered into force in 2021. For reference, the UK-EU trade deal is an incredibly long and complicated document. For some research work I did not long ago, I had to read it in its entirety and pick out specific provisions, and it wasn't a very fun task that I had to do. But essentially, this entered into force in 2021, so the transition period ended at the start of 2021. There have been some significant Brexit-related issues since this. So, of course, we have debate about the Northern Ireland Protocol. We have debate about the Internal Markets Bill and the extent to which the United Kingdom broke international law in essentially rejecting the Internal Markets Bill. And we also have the potential for economic recession as a result of leaving the European Union, which is, of course, impacted as well by the COVID-19 pandemic.